As expected, the Department of Labor recently issued some additional guidance with regard to the participant level fee disclosure obligations under the 404A5 regulation. This guidance we were expecting. It came out in the form of a Field Assistance Bulletin, namely Field Assistance Bulletin 2012-2. And this FAB, as we call it, had 38 frequently asked questions, focusing again primarily on the 404A5 obligations. Now, there is expected a second wave of FAQs that will focus more closely on the 408B2 regulation. That's the one that requires covered service providers to give certain information about fees and services to a responsible plan fiduciary. So that guidance is forthcoming, but the guidance we got in the FAQs on participant level disclosure should be quite helpful. In particular, there was one issue that the ASPPA Government Affairs Committee did write to the Department of Labor about with regard to the characterization of asset allocation services or model portfolios under the regulation. In particular, we were concerned with the potential for these asset allocation services or model portfolios, which enable participants, assist them in dividing up their account balance amongst the designated investment alternatives the plan offers. There was some concern that these models might be considered an independent designated investment alternative of their own. Which would be problematic because it would mean the model would need to have its own 1, 5, and 10-year performance history provided to participants. It would need to have its own website and a number of other items of information that, frankly, we really didn't think were relevant because the mutual funds or other investments that make up the model that are otherwise available to participants as designated investment alternatives, that's really what participants need information regarding. And so we were happy to see in FAQ number 28, the DOL agreed with our letter and indicated that a model portfolio is not to be considered a designated investment alternative of its own if it is clearly presented to participants and beneficiaries as a means of allocating their account balance amongst the plan's designated investment alternatives. So it really relates to how the model is presented to participants. In contrast, that same question 28 points out that if a participant acquires an equity interest or a unit of participation in an entity that itself then invests in the plan's designated investment alternatives, then that would be considered an independent designated investment alternative, which would need a website and the performance history and other information disclosed to participants. Our members tell us that most of their work is in the former category where they are not dealing with a unitized model. And so we were very happy because our members also report to us that these models and asset allocation strategies are a big assistance to participants in being better investors. So we are appreciative of the DOL guidance. There are some issues in the FAQs that may prove problematic, and we'll give you an update on those in the future.